Good morning and welcome everyone to our webinar today on copyright protection, protecting your brand's content and products. My name is Rebecca and I'm the practice group leader of LegalVision's disputes team, and I'm joined today by my colleague Charlotte, who's a senior lawyer in our team and one of our experts in advising on intellectual property and intellectual property disputes. Before we begin, just want to cover a few quick housekeeping items. You'll be receiving a recording on these slides in your email. You can submit any questions that you have for Charlotte and I in the chat box, and we'll answer them at the end of this webinar. And please let us know what you think by completing the feedback survey after the webinar. Also, all attendees today are eligible for a free consultation with us to discuss how we can help you with your intellectual property questions or any of your legal needs. To request a free consultation, just leave us with your contact details in the survey that appear at the end of this webinar. So today, we're going to be covering a number of topics. What is copyright? What is copyright protection in Australia? What is brand and what's a brand protection? How does copyright interact with your brand? What you need to do to monitor for infringement of your copyright and how to take action, and what formal or informal processes you might want to consider in enforcing your intellectual property, how to deal with overseas infringement, and then finally turning to some of your questions. So make sure that you submit any questions that you have throughout the webinar using the chat function, and we'll get to them at the end. So to get started, Charlotte is going to speak to us about what exactly is copyright.
Thanks, Rebecca. So copyright can be a really important tool for brands, as it can offer a really broad and effective protection over your brand assets if they are considered creative works. So essentially, copyright protects original artistic, literary, musical, dramatic works, including things such as books, movies, songs, software code, and other creative expression. In order for a copyright work to have protection, it must be original, and there must have been some skill and effort involved in creating it. This is a pretty low bar. Essentially, it just means that you have to have independently created the work and not copied it from somebody else, obviously, and there must have been some kind of creative choices employed in developing it. It also must have been put into some kind of tangible form, so it can't just be in your head. You have to write it down or draw it or something like that. So importantly, copyright does not protect ideas, just the expression of those ideas. So for example, say you draw a picture of a flower. It doesn't constitute copyright infringement if I then go and draw a photo of a flower, as long as I didn't copy you or they're substantially different. So copyright doesn't protect things like concepts, equations, formulas, recipes, in certain circumstances, mass-produce 3D articles like furniture. People and their images, and single words, names, titles, and short phrases, which are things that are more protected by trademark law. Copyright gives the owner of the work the exclusive right to use it however they please, so including things like reproducing the work, forming it, displaying it, creating derivative works, which are further works based on the original. So when you see a movie made that's based on a book, that's something that would be considered a derivative work. So copyright can be particularly helpful for brands wanting to protect their assets, as it extends to things like logos and marketing material, website content, advertising campaigns, photographs and images of any kind. So unlike any other area of intellectual property, copyright automatically applies for works that are original as soon as they are created. This means that copyright protection arises without the need for registration or any other formalities. This is particularly beneficial for businesses because there's no cost in registration or waiting periods that you need to account for like there are in trademark law. The owner of copyright is presumed to be the individual who first creates that work. However, this can be assigned by contract. Importantly for businesses, it's good to know that an employee who creates a work during the course of their employment the employer usually owns that work, but the situation is different for independent contractors. So in a situation where you hire an independent contractor to create a work for you, the independent contractor usually retains copyright in that work unless it's assigned by contract. So that's really important when you're hiring a web designer or a graphic designer. You should certainly have contracts in place which really sets out who owns the copyright. Copyright is particularly useful as well because the duration of the work, the duration of protection is quite long for intellectual property. The usual position is that it's the lifetime of the creator plus 70 years. So this is much longer than other areas like design, which is 5 to 10 years of protection, or patents, which are 20 years. However, when the duration of copyright expires, the work then enters the public domain and anyone is free to use it. So some examples of works in the public domain are things like the Mona Lisa, and Mickey Mouse is supposed to enter next year, which has been quite contentious. While registration is not required, you might consider putting others on notice that you are the copyright owner by using the little C symbol in the circle that you might have seen before. Essentially what this does is puts other people on notice that you assert copyright over that material and that you are potentially willing to enforce your rights. It can also be really helpful if you intend on licensing your work, because somebody can see that symbol and your name and then go to you directly and offer to pay a certain amount to license that work. It can also be helpful in a dispute because it clearly sets out when the work was created. And if the symbol is on there, it also provides evidence that the infringer knew you were the copyright owner. So now on to Rebecca to talk about brand protection.
Great, thanks, Charlotte. So look, what's the key difference when we're talking about IP and your brand? Well, as Charlotte sort of already outlined, intellectual property refers to creations of the mind, such as inventions, designs, symbols, and names that are used typically in commerce. But when we're talking about brand, we're talking about all of the different things that make up the image that you're projecting into the marketplace. So it's all of the things that make up the reasons why and how a consumer will recognize you and what you are selling or the goods that you supply, and what makes you, your business and your brand unique and distinguishable from other competitors in the market. So brand encompasses a whole raft of different things. It's your company's name, logo, tagline, and overall identity in the market. Brands are really important to protect, and in Australia there is a number of ways that you can protect your brand, and depending on what you're trying to protect. So you can obviously take steps to register your logos as trademarks. If you have designs that you can register, you can certainly register those in patents. But you can also rely on the Australian consumer law in terms of brand protection and copyright. But today's focus is, of course, on copyright. So when we're talking about copyright and the importance in its interaction with safeguarding your brand, we're going to focus on some of the elements that can be clearly copyright protected. So firstly, your logo design. So logos are an integral part of your brand. They can be protected under copyright law if they meet the criteria of originality. So for example, let's talk about the iconic Apple logo. So in addition to being protected as a registered trademark, it's also protected by copyright, and that's because it's an original work of art. And the protection that it affords means that it can't be replicated by other businesses. Your marketing collateral, so any brochures, pamphlets, or any other marketing materials that you publish can be protected by copyright, which helps safeguard your brand's unique messaging and visual presentation. Your website content. So the content on your website, including any text, images, or videos that you upload, can certainly be protected by copyright. Aspects of your packaging and labeling can also be protected by copyright. And certainly jingles or any audio references that you want to have associated with your brand can also be protected by copyright. So let's look at some, fairly well-known examples of things that can be protected by copyright. So we discussed already the Apple logo. So the importance of it being able to be protected by copyright in addition to being a trademark means that you have far more protection in respect of your particular logo. To enforce a trademark or an infringement of trademark, the other company that's using that particular logo has to be using it as a trademark of their own business. So copyright protection can step in where another company or brand is using your logo, but not necessarily as a key aspect of their particular branding. So let me just clarify what that means. So for example, let's think about, a company that is not in the computer manufacturing business. Let's say that they're promoting, apples. They sell apples, and they have a completely unique brand, but as part of their marketing material, they've inserted the Apple logo. Now, that is certainly protected by copyright, and Apple would be able to enforce the intellectual property rights to say, look, you might not be using this as a key part of your actual trademark, but you're certainly not authorized to use that image, and they'd be in a great position to have that removed. Similarly, the Starbucks green mermaid logo is a fairly well-known logo, and it's an immediate brand recognition when we're thinking about Starbucks. So certainly, if another company wanted to set up another coffee shop and use the same logo, you would have a clear claim for trademark infringement. But let's say, a fashion designer wants to create a T-shirt and uses the Starbucks mermaid logo. They're not using it as their trademark, but they're certainly not authorized to use it. And that would be a clear case of copyright infringement, where they're using the logo without authorization. So Starbucks would be able to protect their branding by not have it on sort of unauthorized products. So the next one would be Disney characters and artwork. And as Charlotte flagged earlier, we're heading into some interesting territory with Mickey Mouse coming into the public domain next year. But Disney is fairly well known for maintaining a pretty strong hold on their intellectual property. So there's a lot of beloved characters and artworks that are clearly associated with Disney. And they have the exclusive rights to authorize the licensing of their copyrighted images. So for example, Disney Princess range. As a mum with a young daughter, we've got everything in the sun that has a Disney princess on it. But Disney would license their images to sort of manufacturers. So for example, a big company like Cotton On, there would be a license that will allow them to use those copyright images. If some sort of company decided to set up a business that used created pencil cases or other items that had Disney princesses on them, then certainly Disney would be in a great position to enforce their copyright. Same with luxury fashion brands. So let's take Louis Vuitton, again, another very well-known logo. Copyright is a really important tool for high-end fashion brands to protect their unique logos, patterns, design, and fabric prints through copyright, and helps them to maintain exclusivity. So the copyright protection would allow Louis Vuitton to take legal action against manufacturers and sellers of counterfeit goods and helping combat sales of fake products, which can damage their brand and revenue. So if we actually look at our own LegalVision website, there's some clear examples of how small businesses can use copyright to protect their brand. So for example, our logo, so in addition to being a trademark, it's also protected by copyright. The photographs on our website, again, protected by copyright, which would mean that another website couldn't download the images that we have and put them on their own website to try and save themselves some money in marketing costs. The content that we publish, so again, if someone were to copy and paste that content, put it on their own, then we would have a legal claim against them for copyright infringement. And certainly the vast resources that we have published, our articles and publications about areas of the law would all be protected by our firm's copyright. So you've got copyright. What do you do to protect your copyright? Well, Charlotte's going to talk about monitoring for brand infringement.
Thanks, Rebecca. So while people usually become aware of infringement organically, there are ways that you can proactively monitor the use of your copyright. Monitoring copycats is an essential practice to protecting your brand and something we would certainly recommend that you do. So some of the ways that you can do this is by conducting regular searches. So just searching via search engines, social media platforms, online marketplaces, industry-specific websites, where you can identify any unauthorized use or similar works. You can also use image recognition tools like Google image search, or set up Google alerts for certain phrases or particular keywords or so on. Essentially, what you want to do is be aware of your competitors and take note of them, how they're promoting their brand, is it similar to your own, are they using any similar advertising to you or logos. You also want to keep records. So if you do find anything that you think might be an infringement, you want to record details such as the date or location. Screenshots are really helpful. And then, so some instances, it might not amount to copyright infringement, but it might be worth recording anyway, because some businesses might be skirting the line of copyright infringement, and you want to keep monitoring them to ensure they don't cross that line, which is quite possible, and go further. You can also employ brand monitoring services, so you could engage a law firm like LegalVision to assist with monitoring the marketplace for any similar branding that looks problematic, both domestically and internationally. This is actually something you could discuss in your free consultation, so remember to provide your contact details at the end. Consumer feedback is an interesting one. That's something that we see a lot. So your customers might notify you of a copycat through like Instagram comments or reviews, and they're obviously the prime market for causing damage if they're confused or they're misled in any way, or it affects them, it obviously affects your business. So always listen to your consumers. So what to look for is really businesses that are offering similar services, might be using the same logos, similar logos and branding to your own. And if they do come to your attention, then get some advice. So generally speaking, the first thing you should avoid doing is getting in contact with the business right away. You'll first need to monitor the activity, collect as much evidence as possible. This might be by taking screenshots, as we said, or documenting any instances of confusion. Once that's done, you'll need to assess your own legal position by getting in touch with an IP lawyer. The benefit of this is to understand if there are any gaps in your protection and whether other businesses might have counterclaims against you as well. So as a lawyer, we could review the screenshots you've collated and assess your position and whether there's actually a claim there. So if it's been established that there is a claim, that's when you can take action. And there are several formal and informal ways of taking that action, which Rebecca will discuss with you in a moment. Just before doing that, just a quick note, you should consider taking action as soon as possible after identifying that you do have a claim for several reasons, including avoiding incurring any further damage to your brand, and also sending a message to further potential infringers that you take this seriously, because that can be a huge deterrent in avoiding any further infringement down the line.
Great. Thanks, Charlotte. Look, certainly it's really important to take swift action, but firstly you've got to decide what kind of action should you take. So firstly, you could undertake some informal processes. And it really depends on the nature of the infringement as to what kind of processes that you should undertake first. Obviously, if it's high value, you might want to start with a more formal route, but potentially you might want to start down an informal process to see if you can't just reach a commercial resolution. So firstly, contacting the other party. It's really important to clearly explain your ownership rights and how this other competitor is infringing your intellectual property rights. You should request that they cease the infringing conduct or modify their branding to avoid confusion. It's also important to detail the impact of the infringement that it's having on your brand. For example, a good one is confusion in the marketplace. So if you've got clear examples of consumers being confused, you know, it's really good evidence, and perhaps both brands might be willing to try and avoid that. It's probably in both their interests that there's no consumer confusion. Now, if those informal discussions don't get you anywhere, you might explore if you've got any other sort of formal takedown options that you can undertake. So firstly, if you're a small business that is promoting your business via social media platforms, they often have takedown mechanisms in place to address intellectual property infringement. So certainly Facebook, Instagram, Snapchat, they have some pretty strict intellectual property policies in place, and you can certainly submit a request that certain images or a page is taken down. The other party will have an opportunity to put forward their case on whether or not infringement has not taken place, but it's certainly you know, a good avenue to get some swift action. There's also you know, other internet-based processes, you know, more in America than in Australia. So one example is the digital, I always get this confused, I think it's the digital marketing, blah, 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 I'm not quite sure. Charlotte, do you remember what it's called?
Gosh, I don't know the acronym.
Yeah. Anyway, it's a DMCA takedown request. I can't remember exactly what it stands for, but I only know it by its acronym. So certainly it's an online mechanism. If you encounter a website that's hosting some infringing material, you can make a request that that website be taken down immediately. Then there's some follow-up interactions to whether or not infringement has actually taken place. So there's some informal options. Again, if those processes don't get you where you need to be in order to enforce your intellectual property rights and protect your brand, then it might be time to level up. The last resort, of course, is commencing litigation. The Federal Court of Australia is the appropriate forum to resolve copyright disputes. And in addition to a copyright infringement claim, you may be alleging or want to allege that this other competitor is engaging in misleading and deceptive conduct, which is prohibited under the Australian consumer law, or they've engaged in the tort of passing off. So what this means is that this copycat business is trying to trade off the goodwill that you've established in your brand and mislead consumers into believing that their company is actually your company. So trying to, you know, potentially siphon off customers that might be coming to your brand to their brand. But again, before you commence any proceedings, it's really important to make sure that you've got a firm legal position. You should engage a lawyer to prepare a formal cease and desist letter, which sets out a number of demands, including that the infringer immediately cease the infringing conduct and put them on notice of any other remedies that you might be seeking. Now, as an alternative to court action, you might want to consider trying to negotiate a compromise with the copycat business, where you license your material to them for a fee under a formal contract or license agreement. If you do need to commence proceedings, you can ask the court to provide you with a number of remedies. So firstly, injunctive relief. So this is aimed at stopping the infringement from continuing. Damages, which is to compensate you for your losses that have been suffered as a result of the infringement or the damage to your brand, or an account of profits. So where a copycat business has profited off your infringement, you would be entitled to make a claim to the extent that they've compensated. Then you should be basically getting that money instead of them. Now, litigation can be a pretty costly exercise, I know from experience. So it's really important to weigh the damage the infringement is causing to your business against the cost of litigation. Now, brands are something that are really important to protect. So often you've got to think about perhaps the upfront costs of trying to deal with infringement swiftly and quickly, potentially through litigation, versus if you let the infringement continue, what financial implications could that have for your business in the long run of, not protecting your brand and potentially losing businesses to other copycats. So finally, Charlotte's just going to speak briefly about what to do if your brand is being infringed overseas.
Sure. So we've spoken a lot about what to do in Australia if your brand is copied, but it's also important to note that a lot of your businesses are online and trade is conducted across borders. So it's likely that an infringement might occur in a different country. It's worth noting that Australia is a party to various international copyright treaties, so your copyright can be recognised overseas in most cases. If an infringement does occur in another country, you should speak with an IP lawyer to understand which country is best suited to bring any claim that you might have. So, for example, you might choose to avoid the US, where they have really broad defences available, and go to the UK or something which has similar defences available than Australia. Or you might also consider what countries have the fastest resolution time and the costs associated with lodging those proceedings. So just to quickly summarise, we've discussed a lot today about businesses being proactive about protecting their brand. This obviously starts with identifying what your brand assets are and if they're copyright protectable, and monitoring for any infringement that occurs. And really the best way of doing that is to understand how copyright law works and how it protects your assets, and then taking steps to enforce that or those legal protections that you have. And hopefully we've helped do that today.
Great, thanks Charlotte. So look, this concludes the formal part of our webinar, and we're about to get stuck into your questions. But you might find our guide, which is protected by copyright, guide to protecting your brand useful. So you can download this in the handout panel of the webinar, or you can scan the QR code that's on the screen. We've got another webinar that might be of interest to you, which is Real Estate 101, your advertising compliance requirements, and that's coming up on Tuesday, 31st of October. If you're interested, you can register following the link on the screen. Now, finally, we're just going to briefly talk about our membership model. So LegalVision is a membership. Legal membership is a cost-effective and alternative to have all of your business as usual legal needs covered for a fixed monthly fee. So not only will you get cost certainty, but all-inclusive benefits such as unlimited document review, which would include reviewing your intellectual property documents or commercial contracts, unlimited consultations with our board legal team, so you could discuss your intellectual property rights or commercial contracts or any other business as usual legal needs. And certainly your membership would also include unlimited trademark registration. Now, all of this is for a very reasonable monthly fee, and with options to purchase extra credit that can be used towards complex matters such as ongoing disputes or enforcing your intellectual property rights, which are generally charged on an hourly rates basis. Okay, so let's jump straight into some of your questions. First question is, how can I ensure that I own the IP I share with manufacturing companies such as imagery, photos of art, and the art itself, which is for sale once it's advertised by turnkey manufacturing companies? Charlotte, do you want to cover this one?
Yeah, sure. So that will really depend mostly on your agreement with those companies. You should always have a contract with anyone that you enter an agreement with for manufacturing or designing, which clearly sets out who owns the IP in the works. We see a lot of problems come from these kinds of arrangements, and it's not defined who owns what. So that's really what you should be looking at. You can also consider like non-disclosure agreements and things like that if you're discussing product development with a company in the initial stage, but you will have copyright protection if you are the creator and they share those works without authority. But really, yeah, the crux of it is that you should be entering into an agreement before you do anything with any third party.
Great, thanks Charlotte. So another question here, if your product packaging is unique in the field and is a brand differentiator for your product, what protection could you enforce if the US competitors copy this packaging, including the way that you display information on the packaging? So Look, if the packaging is considered an original artistic work, then you'll have copyright protection in the US that you can enforce, as Australia is a party to various international copyright treaties. So that means that you'll be able to enforce your intellectual property rights overseas. If it's shared without your permission, then you would have a copyright infringement claim that you could enforce. So look, certainly being able to rely on your copyright protection there. And if you need some specialist advice in particular to this scenario, please book in a call. Can you please advise on what online material is implicitly protected and what needs explicit statements? Look, I'll just cover this quickly. As Charlotte outlined, copyright protection automatically applies if it's an original creative expression. So you don't need a explicit statement published in order for it to be protected. That protection is automatic. What it might be a good idea is using that copyright symbol to make it very clear that things are protected by copyright, or if you're certainly publishing things on a website, having some standard terms and conditions on your website that make it clear that the content that you publish is subject and protected by copyright. Another question here, our business provides marketing, photography, videography and drone video and images for real estate. How can we protect ourselves from other agents who pull our images from third-party sites and use them without contacting us? Charlotte, throwing this one to you.
This is a really good question. And going on from what Rebecca just said, this is a good opportunity to use the copyright symbol to put those agents on notice. A lot of the time, people don't actually understand copyright law, as they, don't necessarily have to, but a lot of the time they'll take those photos of properties and share them because they don't realize they're doing anything wrong. So by putting that copyright notice on it, it really tells them that you are the copyright owner and you're going to enforce your rights if they use those photos. You can also think about putting watermarks on your photos to deter infringement, and also that's proof. If they remove that watermark, it's proof of further copying and infringement. That can be helpful down the line. At that point, if they're doing that, you could also just engage a lawyer and send a letter. They might be able to pay you a licensing fee as well. That's something to consider.
Yeah. Another good question, how do we stop YouTubers from promoting fake copies of our products and using misleading product names? Well, as I was discussing earlier, a lot of the social media accounts, including YouTube, have takedown forms that you can lodge. So as soon as you see your brand being compromised, you should let YouTube know that there's a video that contains infringing material, and they will take it down. The infringer will, of course, have an opportunity to go back to YouTube and say that the material is not infringing. But if this happens and the content goes back up, then certainly you should be contacting a lawyer and trying to take some further enforcement action. Okay, I've got a question here. If I've been using the term, for example, jelly band already, can I copyright it? And if so, can someone register jelly band? So look, words of themselves are not really things that can be copyright protected. These are sort of more, this is a question that's sort of more in the trademark territory. So recommending that you get some advice in relation to what rights or trademark rights that you have. So maybe booking a call with us to discuss further. A question here, and I'm going to throw this one to you, Charlotte. Where copyright would normally be owned by the individual who created it, accordingly, would typical employee agreements that deal with the assignment of IP to the business cover the assignment of copyright to the business entity?
So this just depends on the circumstances. So if the individual creates it outside of the scope of their employment, then they will retain copyright. If it's something that they create within their employment, like for example, I prepared some notes for this presentation, I unfortunately do not own the copyright in it because I signed an employment agreement with LegalVision where my copyright is assigned to them in those situations. So often an employer will include an agreement, a clause in the employment agreement which handles that, but certainly you don't give all of your copyright away as an employee if it's outside that scope of employment.
Great. What is the situation when a design or brand creates material or logo for you? Who owns the copyright? So Charlotte discussed this earlier. If you engage an independent contractor, for example, a designer, to create intellectual property for you, the default position is that they own the copyright. So what you've got to make sure is that when you engage someone, you have a really clear contract between the two of you that governs, you know, what rights you have to that intellectual property. Whether or not you're simply licensing it from them for a fee, or whether you actually own it outright. So before you launch into engaging anyone, make sure you get some legal advice about what should be in a contract. Charlotte, another one I've got for you, does copyright cover slogan? So if we use a particular slogan to promote a product in our business, would we need to trademark it to protect it?
Essentially, yes. Copyright doesn't usually protect slogans. They're not considered original because they're short phrases and so on. So trademark is really where you'd be looking to protect your rights there.
Yeah, great. Look, kind of a similar question. Why would a company trademark the logo as well as the name if the logo images is protected by copyright anyway? Look, that's a really good question, and it comes up quite often with our clients. You know, trademark registration is a really, you know, great way of protecting your company branding. Now, registration provides a pretty clear, you know, communication to the rest of the market that you own that logo. Now, there may be certain situations, now I was talking about where, you know, a company, another competing company, or just another random third-party company might use your logo, not necessarily as a trademark, but just as an unauthorized reproduction, and that's when you would rely on your copyright protection. So when it comes to your logos, certainly the best frontline defense that you have is registration as a trademark, and then copyright can certainly come in to support your legal claim, but also support it in other ways where perhaps the trademark protection doesn't necessarily assist you. But it's a very complicated question, and certainly one worth getting some legal advice on, just to clarify when you need to have trademark registration. Okay, so look, so many questions coming in, which is really great. We have a trademark over a brand and a logo, and another company has now tried to copyright it as well. Our business is clothing and their business is a podcast and clothing. Look, this is a pretty specific question, and I would recommend that you book in a consultation with us, because we'd love to have a chat with you about this. But if you've got trademark protection, then you should be certainly enforcing those trademark protections. And certainly if another company has copied your logo, you've got protections in copyright. So you've certainly got rights to enforce, and I would be recommending that you enforce those rights. So if you'd like some legal assistance, you know, please reach out to us. Another question that I'm just going to throw over to you, Charlotte. I have watermarks on my images. However, another company is removing my watermarks and placing their own watermark over the image. Would having a copyright symbol stop that?
It wouldn't stop them from doing it, but what they're doing is certainly an infringement of copyright. It's also an infringement of your moral rights under copyright, which is a separate protection, where you have a right as the copyright owner to attribution. And so what they're doing there is infringing your regular copyright and also infringing your moral rights as well. You could certainly include the copyright notice, because it would help deter them essentially, or hopefully, but it wouldn't necessarily stop them. If they are removing the watermarks, they obviously you own them. And in that case, I would suggest that you get in touch with us and we discuss that one further.
Yeah, agreed. And certainly if you were enforcing your intellectual property rights in the courts would probably take a pretty dim view of a party that is obviously on notice that those images belong to someone else, and on notice that they're subject to copyright, and taking that symbol off them. I think that the court would have consider that in, you know, making an award of damages against that party if you got that far. Okay, let's answer this Disney question. If Disney has licensing agreements with manufacturers of fabric and I buy that fabric, can I use it to make the clothes to sell? That's a good question. So you'd want to make sure that the agreements that you have with this manufacturer when you purchase it, if they are licensed to use those images, that there'd be some sort of sub-license that would be passed on to you. So that's a really good question, and I definitely recommend getting some legal advice in relation to the contracts that you have in place with this particular manufacturer. Charlotte, I noticed that the copyright statement on the bottom of your presentation does not have a date. Does this mean it's not properly protected?
No, it doesn't. The copyright notice doesn't have to be written in a particular way. The symbol itself is just to notify people that you own copyright. You don't have to include the date. It's just helpful in knowing the duration and the details of how it applies and so on. But no, it doesn't take away from the notice. The notice with the symbol is just as effective.
Great. Look, we've got so many questions, and I don't think that we're going to be able to cover them. So we'd really highly recommend you to book in a complimentary consultation with us once the survey pops up at the end of the webinar, because you've got some really great questions, and we'd really love to speak with you about them. We might just cover off one more before we have to wrap up for today. Let's see. Can a company be the copyright owner rather than the individual? Certainly, yeah. So, that's certainly the case. Companies can definitely be owners of intellectual property rights. And so, for example, LegalVision, the company is the entity that would own the copyright, this presentation, and certainly all of the materials that I outlined earlier that are published on our website. So no, it doesn't have to be an individual. It can certainly be a company. Look, that's all we've got time for. Thank you so much for participating. Your questions have been excellent. It's been a really great conversation. Thanks, Charlotte, for joining me for this great chat about copyright and brand protection. So look, please book in your complimentary legal consultation after the webinar ends. The survey will pop up. We'd really like to hear from you about what you thought about this webinar. So please complete the 30-second survey, and don't forget to leave your contact details to receive a complimentary consultation. Thank you so much for joining us. It's been a pleasure, and we look forward to the next webinar.